Hello, Todd Smith here with another appellate tip of the week. This week's tip: don't bother opposing routine appellate motions. What do we consider, you may ask, to be a routine motion in appellate courts? Well, the best example is a motion for extension of time to file an appellate brief. You'll see those in the intermediate courts of appeals and in the Texas Supreme Court. You'll see also extensions of time requested to file a petition for review in the Texas Supreme Court. So that's kind of the parameter we're talking about here when I reference routine motions. We're not talking about things like a motion for contempt for failing to comply with a trial court order that's on appeal, as in a temporary injunction situation, or a motion to dismiss for lack of jurisdiction. We're talking about sort of routine administrative type issues that come up that don't affect the merits of the case. So the things to know in this situation are, for one, your opposing counsel is going to call you when they file a motion like this, and they're going to need to confer with you according to the appellate rules. And so you're going to be put in the position of having to tell your opposing counsel whether you oppose, your client opposes the relief that's requested. In reality, extensions of time are just a part of appellate practice. If you handle a lot of appeals, you're going to inevitably rely on extensions to get your work done, because you just can't sit at a computer 8 hours a day every day, or 12 hours a day to try and meet your existing deadlines. If you've got multiple briefs due around the same time, an extension is just going to be a way of life and a way of coping with those kinds of deadlines. And so another thing to know is the appellate courts realize this, and so they've given the clerks authority to deal with these motions, particularly first motions, whether they're opposed or not, and even second motions, and to issue an order granting them without even bringing the motions to the attention of the appellate justices. So these orders don't even make their way to the actual judges usually. They're so routine that they're granted just by the clerk's office issuing the order. Now, this gets to be a closer call if you get past about a second motion for extension of time. I think in that instance, the justices sometimes become aware, but even if it's just the clerk's office that's issuing the orders, you will frequently see a rather sternly worded order come out that says further requests for extensions will not be entertained, or the message being, don't do this again. We're going to give you this requested extension, but let's get your brief in by this deadline. So what's the right response here? If you're approached by opposing counsel about an extension of time to file a brief, well, you really shouldn't oppose it for several reasons. For one, it shows that you don't really know how things are done, that these things are handled in the clerk's office, that they're routine. The courts are generally going to be very lenient about extensions of time. And if you insist on opposing a motion, it doesn't look good for you as the advocate. And it's not a reputation that you want to get as someone who opposes motions that really are going to be granted 99% of the time anyway. And just also the party line, I have to check with my client and get back to you, is really not a good play. What you should do as someone who has got a matter going up in the appellate courts, you need to condition your client that extensions are just a matter of routine, and that's why they're routine motions, and the appellate courts freely grant them, and opposing them is not going to do any good. In fact, is going to cast a little shadow on your side of the case. And so you really ought to be prepared when you hear from your opposing counsel to just be able to go ahead and say, yes, that's not going to be opposed, and move on from there. Because that's not the reputation that you want, either in one case or beyond that, as being someone who is just going to oppose something for the sake of opposing it. Now, there may be good reason in certain circumstances to oppose what might otherwise be a routine motion, and I don't want you to feel like you shouldn't take a stand if it's a stand worth taking, but the vast majority of cases don't fit that scenario. The vast majority of the time, the court is going to grant a motion for extension no matter what you say or do, And your time and energy is best spent, and your reputation are best spent appearing to the court that you're trying to work with opposing counsel and being reasonable. That's it for this week. We'll see you for next week's tip. Till next time.